start out by saying that no one questions the ability of Phelps to picket, to say whatever they want. It is, no matter how repulsive, and I would suggest to somebody who studies religion, theologically, we'll use the word interesting, you know, the views are, you know, there's no question that individuals have a right to protest. That's not what this case is about. This case is actually about what are the limits that the court has already placed on First Amendment speech, and specifically two limits. The ability of the government to create reasonable time, place, and manner restrictions that are content neutral, and that is key. If any state did pass a law that was called the Phelps Law, you know, that would be unconstitutional because it's not content neutral. Most of the states that have passed these funeral protest laws, some of them are temporal, i.e. you can't protest during or a half an hour before or half an hour after the funeral. Others are you must be however far away from it. As long as that applies to all funerals and all protesters, these laws are content neutral and they meet reasonable time, place, and manner restrictions. Second of all, in terms of the tort aspect of this, I'll talk about that in a moment. Nobody's saying, even if Snyder were to win, and one thing I do agree with Ms. Phelps on is that there were some significant problems with the record at the trial court level in this case, and that there was a real question about the judge giving a legal question to the jury as a fact question. That was a real problem. But putting that aside for a moment, when we look at this sort of a case, the question is, what about right of privacy? What balance can exist when we have individuals engaging in free speech rights that allegedly invade someone's privacy and inflict harm? The individual suing is a private individual. This is not the government coming in and shutting down the speech. Technically, if there was no statute, they could keep protesting funerals. But if someone is able to demonstrate that what they did rose to the level of intentional infliction of emotional distress, they can then sue, and then, you know, if the church wants to keep paying, that's fine. It's very hard to win a claim for intentional infliction of emotional distress, so the likelihood is the church is going to win most of those cases. But you know, the court system is still being used, so that raises First Amendment questions as well. But let's look at this in terms of the main issue here, which I don't think is the specific Snyder v. Phelps case, but rather, what is government's right to engage in reasonable time, place, and manner restrictions around a funeral, not just military funerals, funerals generally? And to answer this question, and the Fourth Circuit's decision, there are many questionable legal aspects to the Fourth Circuit's decision. Only two of which I'll discuss here, and much of the decision is actually quite good, but one of the things is equating the funeral to more of a public event rather than a private event. There is a long line of cases in the United States pointing out that protesters, even on public sidewalks, do not have a right to harass individuals in their homes. That your home is off limits to this sort of a protest. There have been some exceptions made for, you know, truly public figures in certain circumstances. This is absolutely, you know, sort of black letter to the extent that there is anything such as black letter law in constitutional law. Those of you happy for constitutional law. But the other question that relates to that then is a funeral, particularly the Snyder funeral, funerals like that aren't in a public school gymnasium with the governor there, but are actually held in churches or at cemeteries, whatever the case may be. Are these more like someone's home? Are these more a private space where government does have the right to say, at least with reasonable time, place, and manner restrictions, you cannot interfere with that? Or are these more like a public forum where certainly you have, I mean, the Phelpses, if they want to go to a public forum today and protest and say whatever they want, no matter how inflammatory, I'd be the first one out there defending the right to do that. But the question here is, when they're doing it in front of a military or any other funeral, is this more like protesting a private home? The fact that you're on the public street is all part of the context of free speech protection. So 2 things here. 1, if government wants to raise reasonable time, place, and manner restrictions, then as long as they're content neutral, and in the most of the states where these funeral protest laws have occurred, they are content neutral. The only other question is whether they're tailored appropriately. In other words, is the restriction too broad? Are they limiting channels, alternative channels for speech? So is the time limit on the protest too broad? Is the space limit too broad? That could be a problem. But as long as it's content neutral, it's fine. Now, there are 1 or 2 states that it seems pretty clearly targeted specifically at the Phelpses, and that would not be content neutral. But that's a different matter from the broader issue here. I also want to point out that I agree wholeheartedly about defending the Constitution. Needless to say, I have great love for the Constitution. But the interesting question here, I recall when I was teaching First Amendment law a long time ago, back in the Cretaceous era, when a student, a Vietnam vet actually, older student, came up, and afterwards we'd done the flag burning case, Texas v. Johnson. And students were very upset about, being able to burn the flag. And, the student came up, and I didn't know what he was going to say. He came up to me afterwards. He said, I'm really ticked off because my friends died for the right to burn the flag. And, I'd love to go kick anybody's rear who burns the flag, but, my friends died for that right. The question is, are these Phelps protests like someone burning a flag on a state capitol lawn? Or are they more, as I would suggest potentially, more like burning a flag already folded into, funeral format, and burning it at a military funeral with signs calculated to upset the family and at least plausibly disparage the fallen soldier. Now, this is the question. Is that the same as Texas v. Johnson? Is that the same as the right to burn the flag? And, I think that's an open question. And every protest is different. The First Amendment is contextual. But I do want to point out a Kansas case involving the Phelps Church that points out the sorts of things that can happen. And I agree with Margie Phelps 100% that in this case, this particular sort of thing did not happen. But again, we have the private-public aspect here. But they protested in the 1990s an Episcopal church in Kansas. And the case went up to a court of appeals in Kansas. And one of the questions, and this gets to your point about fighting words, then there was a TRO and ultimately a temporary injunction issue. They were protesting not far away, but on all 4 corners around that church. And families with young children were going to the church. And basically the court found that the protesters were engaging in targeted speech at the families as they were going to the church. And that the speech was hateful and in some cases was potentially going to provoke violent response from parents who didn't want their children hearing this. And so it is possible that this sort of a protest could reach the level of fighting words. With that said, my guess is that over time the Phelpses have gotten much wiser about First Amendment law and have avoided this sort of thing, this sort of behavior in that directly targeted way. And so I'm not sure that fighting words would necessarily apply in these sorts of protest cases. But it has occurred, and the tort involved in that case was a nuisance. And the court at least held that it's potentially a nuisance, and therefore a temporary restraining order would issue. One final note, which is that even if the Fourth Circuit was correct about the likelihood of First Amendment violations based on intentional infliction of emotional distress and invasion of privacy based on the actual protest itself, which if you read the facts in the case, the Fourth Circuit said that. The problem is they used the Hustler decision to suggest that that Mr. Snyder's, whether he's a public or private figure doesn't matter. That's one of the legally problematic aspects of the Fourth Circuit decisions. Actually, the result of pretty good briefing on Ms. Phelps' part, and much weaker briefing on the other side's part. But the reality is that when we look at the epic that was published afterwards, that was targeted at Matthew Snyder, even if it had other speech in it. The fact that that speech was, as the Phelpses have characterized it, hyperbolic and hysterical speech, that's their subjective perspective, and maybe many others would view it in such a way. But it's pretty clear they're serious about their views. This isn't, crap to them. They're serious about this. And therefore, it's somewhat ironic to call it hyperbolic and hysterical when it's truly intended and meant. And therefore, I think that Mr. Snyder, if he does prevail, the epic is the most likely ground for that, rather than the specific protest. Finally, as a law and religion person, and since Ms. Phelps did bring up the religion stuff, I'm just going to say one thing and only one thing about that, which is, having been someone who's cracked the Bible, one thing that I will suggest is it's sort of interesting for people to be so sure that they know the will of God. And that itself is a theological debate that we're not going to have here. But I do always kind of find that ironic. But I wanted to tie that in because the First Amendment doesn't care whether someone really knows the will of God or not. They don't care whether someone's wrong or right. The First Amendment is neutral on this. So whether I consider the theology questionable is not remotely important. Whether you consider the theology wrong or reprehensible is not remotely important to the First Amendment issue. They have a right to believe what they believe, and they have a right to protest and support their beliefs. The only question here is when and where, and whether there could be tort liability.
Thanks, Professor Ravitch. At this point, I'd like to open it up to questions from the audience.